We have made it through the contracts, the listing agreement, the purchase contract, the disclosures. Today we're jumping into the addendums that could be attached to, or addenda that could be attached to the purchase contract. They are not in alphabetical order according to ABCD, but just hang with me and we will get through these. The first one we're going to talk about is the contract for deed. It's the Addendum K. Not used a whole lot in purchases. Contract for deed is its own special entity, and that would require a bit more of a discussion. So I'm not going to spend a whole lot of time on that addendum. Basically, there are blanks to fill in. It's a special circumstance that requires an agreement between buyer and seller. Seller typically would need to own their home outright, or if they do have a mortgage on it, the lender would have to approve a contract for deed sale. And that's not usually very typical. So most of the time, the seller owns the property outright, and so they're able to go ahead and accept a contract for deed purchase. Real quick, basically, it's that the buyer puts down a deposit. That deposit amount needs to be an amount agreeable by the seller. It also needs to be enough to cover the commissions involved with the closing and title costs, insurance costs, and then whatever padding the seller would want in that down payment. So a significant amount of a down payment. A lot of times 10% or 15% is used. But that's not a rule. Everything's negotiable, right? And then the buyer would make payments to the seller on a monthly basis as if the seller was the mortgage holder. In general, that's what a contract for deed is. There are a whole lot more terms that go along with that. But for now, we can have that discussion if you have a client that needs to buy contract for deed, or you have a seller who's willing to sell contract for deed, then come see me and we can go through that process together, and I'll teach you that then. The next addendum we're going to look at is the Addendum F. This is a limited purpose entry by a buyer prior to closing. So in bold, we have limited entry is not advised until closing has been completed, and seller is cautioned not to permit earlier occupancy by buyer except under extraordinary circumstances. This form is for circumstances in which a buyer requires temporary access to the property for some limited purpose. For example, storage of personal property prior to closing. If buyer requires occupancy for up to a few days prior to closing, the possession by buyer prior to closing form should be used instead. If the buyer requires occupancy for more than a few days prior to closing, the parties should execute a lease. So the purpose of this limited purpose entry would be, say the buyer and seller have agreed that the buyer can store some of their personal property in the garage a day or two before closing. So this limited purpose addendum would include the contract date, the property address, the seller's names, the buyer's names, and then it details the access that's allowed for the property. Buyer shall have the right to enter the property from blank PM or AM on whatever date to AM or PM on whatever date for the limited purpose of, and it's outlined and defined in whatever terms the buyer and seller have agreed upon. Paragraph 2 says that the buyer assumes full and complete responsibility for any damages or injury that may occur. And then paragraph 3, in the event there's a conflict of this addendum and the contract, then the addendum shall control, and then all other terms of the original contract do remain, but this addendum would supersede once it's signed by all parties, agreed upon by all parties. Again, that may be, like to store personal property on the property. Maybe another instance I have seen is the buyer wants the house professionally cleaned prior to closing, the carpets cleaned or something like that. Not typical, it's not advised because anything can happen, and then there is the question of liability. I know this paragraph 2 says buyer shall assume full and complete responsibility. But things happen. And so the legal advice is always to really steer your clients away from any possession outside of actual ownership. Okay. So there's a limited entry addendum. There's the new construction addendum. That would be in the event the property that the buyer is purchasing is a new construction, and it has to do with the occupancy, the closing, and then the warranties that that the seller or builder provides. New construction is like the contract for deed. New construction is its own beast, and if you are working with new construction, then we can definitely coach you along those lines when and if we get to that stage of your business. So just know that that is an addendum that you would include with new construction purchases. All right, moving down. Personal Property Addendum E. This is usually included with most purchase contracts. Whether it be a shed in the backyard or a freezer in the basement or the kitchen appliances. Now you don't type here kitchen appliances. You have to identify each piece of personal property specifically. So contract dated, property address, seller's names, buyer's names, and then identify the personal property that would be included or that your buyer is requesting to be a part of this purchase contract. Now the MLS may state in the listing, that the kitchen, refrigerator, stove, microwave are included in the purchase. Never assume that. Don't go by what's in the MLS. The buyer is not signing anything with the seller as far as what's advertised in the MLS. So that's just information communicated. When you present this offer for your buyer, you absolutely need to identify the personal property pieces that the buyer is expecting to be included in the purchase. On the flip side of that, say the washer and dryer aren't mentioned in the MLS. They're not included in the sale. That doesn't mean that the buyer can't ask for it. So again, whatever personal property the buyer wants to request, they can request it. So you would identify kitchen, refrigerator. You can be as specific as you want, stainless steel kitchen refrigerator, Frigidaire kitchen refrigerator, side-by-side kitchen refrigerator. The reason I am going into a little more detail on that is because there have been circumstances where a seller maybe has had an old fridge in the garage or the basement and the newer fridge in the kitchen, and they show the house and they say refrigerator is included, and the buyer writes an offer and it says refrigerator, but it doesn't identify what refrigerator. Then the seller removes the kitchen refrigerator and replaces it with the basement or the garage refrigerator that, is clunky and old and maybe on its last leg, if it's even working. There's a refrigerator, and all that was agreed upon was a refrigerator. So kind of important to identify, especially with refrigerators, what appliance the buyer is requesting. So you can say refrigerator that was in the kitchen at the time of showing. You could say, name the brand if you know it. Just another idea while you're in the showing appointment to take some notes as to what is present and what the buyer wants to include in their offer. Oven, stove, range, cooktop, whatever the oven may be, built-in oven, gas, electric, you don't have to have a storybook on the line, but something to identify it to be exactly what the buyer is requesting. As far as the value, you generally put 0 for the values. A lender will require a number here. You can't put dashes or NA. So Frigidaire, kitchen refrigerator, 0. Cooktop, electric stove, 0. Etc. Microwave, whatever. So you list the personal property. Sometimes, and then there's the shed, or sometimes popular would be like a wine cooler or additional freezer in the basement. So you identify each piece. Sometimes furniture may be included, and so, or the buyer may want to request the bar stools or the kitchen breakfast bar stools, whatever. So you'd want to identify those. Again, zero valuation. Now the seller could come back and counter with a different personal property addendum, but the buyer has the right and the opportunity to ask for whatever personal property they want to ask for. So, of course, you want to do that within reason, and if it's a hot market, don't be overzealous. But this is where you would list that personal property. Buyer and seller would sign if seller's in agreement, or sometimes this is a term that the seller would counter offer on. But you definitely want to remember to include that personal property addenda with any offer that you present that does involve personal property. Okay, so the addendum G, possession by buyer prior to closing. Now, if you remember on that limited purpose addendum, it was just to store things. It wasn't to actually occupy. Occasionally, there's a situation where the buyer is homeless and needs to get into the property, and maybe the property's vacant, and the seller could accommodate. Again, in bold and all caps, it's not advised. Definitely want to direct your clients to seek legal counsel. Most attorneys would frown upon it, but there are instances and emergencies where sometimes this is the only way to work it out. So we do have this form available. You always want to preface the use of this form with this note and with the warnings about the fact that it's risky. If the buyer's financing fails, what happens? All kinds of different scenarios. So if you're utilizing this form, or your buyer would like to present this form to the seller, you have the contract date, the property address between the buyer and the seller, their names, and then it identifies the date that the buyer can occupy the property. This would be just for a couple of days. Again, as advised in the previous form, if it's several days, if it's longer, a longer period of time, then you want to have a short-term lease in place, and that would need to be drawn up by an attorney. So the date and time that the buyer can obtain the keys and have possession, the buyer is responsible for all utilities at that point. The buyer assumes full and complete responsibility for any damages or injury. The buyer needs to carry a minimum of $300,000 general liability insurance, naming the seller as an additional insured. Furnish proof of coverage to the seller prior to possession, and the buyer shall be responsible for insuring the buyer's own personal property. So the seller isn't responsible to insure the property as far as liability. The seller would still insure the property for the property, but not for liability and not for personal property. Okay, so the buyer and seller are strongly urged to communicate in writing the exact closing date and possession details with their insurance agents. Obviously, those facts need to be communicated with the insurance companies for sure. And the insurance companies may say, nope, can't do it. So there are just a lot of caveats here. The buyer, by accepting the keys to the property, acknowledge that the property is fully acceptable to buyer in its present condition, except for any repairs which seller has agreed in writing to complete, if they aren't completed yet. The buyer shall deposit with escrow agent as defined in the contract the sum of blank as additional earnest money. This amount is to be paid by cashier's check prior to occupancy of the property by buyer. This is a term agreed upon between buyer and seller. The seller would probably require a much higher deposit of earnest money. Say the buyer only deposited $500 earnest money. This would be an additional amount to that, and then it's credited to the buyer at closing. The buyer shall pay the seller a sum of blank per day for buyer's occupancy described above. This would be like a daily rent amount. The possession granted hereunder shall not be considered a leasehold tenancy between seller and buyer, and if the sale of this property is not closed on the closing date or any written extension thereof, buyer shall immediately surrender the possession of the property to seller. If buyer holds over the scheduled closing date, buyer shall pay to the seller the sum of blank per day as damages. A lot of times this amount here will be much more than this amount here, a significant amount more, because basically this paragraph is providing if the transaction doesn't close, then the buyer must vacate the property, and any extended time they stay on the property, they agree to pay this significant amount more per day. That would be to obviously encourage the buyer to exit the property. In the event seller has to evict the buyer under any forcible entry and detainer statute, all statutory notice is hereby waived. There is the opportunity for the buyer to just have possession of the garage. That's when this box would be marked. There are also special agreements pertaining to occupancy. That would be terms the buyer and seller would identify. Again, you're not an attorney. Do not add any verbiage without being at the discretion of your client and the direction of your client. Buyer and seller agree to hold harmless from liability in a real estate broker and agent participating in this transaction. And then the buyer shall obtain an occupancy permit prior to occupancy if required. So in the purchase contract, it's the seller's responsibility in most municipalities in our area to obtain that occupancy permit. But in this situation, it's the buyer's responsibility. So another fact to communicate with the buyer. Okay. And then paragraph 11, again, is similar language that we saw in the other one. In the event of a conflict between this addendum and the contract, this addendum shall control. All other terms and conditions of the contract remain unchanged or in full force and effect. Okay, so buyer would sign and date, and you would present this as an attachment with the purchase contract. Sometimes you get to, you're 2 days before closing and whatever chaos arises and you need to implement this or present this as an option to the contract, then you would present this with an amendment to the contract. And now we're going to move down to the Addendum B. This is possession by seller after closing. So on occasion, buyer and seller have closed. For whatever reason, the seller is unable to vacate the property. It may just be that their possessions are still in the property. Maybe the moving company had a delay and it's just a last minute chaotic situation. And so maybe this document would come into play. The issue with this one is that, again, you have to be sure that buyer and seller are in agreement, that the insurance companies are in agreement, that the lenders are in agreement, because obviously with a lender, the buyer would have closed and signed their loan documents, and so the lender assumes that the buyer is possessing the property, but no. And a lot of lenders, they don't allow for the other party to occupy the property, whether it's the buyer prior to closing or the seller after closing. So a lot of variables, and again, attorneys do frown on this as well because of all of the liability issues and the situations and scenarios that can arise out of this that cause legal questions. So contract dated, property address, again, sellers and buyers, you identify the parties to the contract, and then the language would provide for the seller to continue to occupy the property for blank days after the closing date, and then in the amount per day that the seller would now pay to the buyer. And then the buyer shall be entitled to receive additional compensation from the seller in the amount of blank per day that the seller retains the property. However, the buyer shall have the right, just like the seller did on the other form, to institute a forcible entry and detainer suit against the seller for occupancy of the property after the agreed time. The statutory notice required by law prior to institution of such suit is expressly waived by the seller. So the seller would have no protection then against the statutory notice. The seller now would then agree to provide insurance. They would have the responsibility for the risk of loss and injury, etc. The seller shall deposit with the closing agent the sum of blank as security. That is a term agreed upon by buyer and seller if they enter into this agreement. The real estate broker, closing agent, everybody is held harmless. And then again, in the event of a conflict, this addendum, the terms here would stand and supersede any of the conflicting terms in the contract, but then all other conditions of the contract would be in full force and effect. Buyer and seller would sign this. Again, sometimes this isn't known or presented until later. It's not a part of the purchase contract that a buyer would present to the seller unless whatever information agreement was made known prior to you writing the offer. But generally, no, this is not. And again, not looked upon favorably. So if this becomes a discussion, definitely advise your client to seek legal counsel. Confer with the insurance companies and the lending companies. Okay, repair addendum. This is the addendum D. Sometimes when you take a buyer through a property and you present an offer and there are clearly known defects and the buyer wants to be sure those are remedied. They don't want to wait for the inspection report to request these repairs. They want to just hit it head on with the purchase contract. So you would mark that addendum D on that page 11 and contract dated, property address, buyers and sellers, and then you would detail the repairs that the buyer is requiring. Again, at the direction of the buyer, you would want to probably make sure that if it's a license, like a roof, licensed roofer to repair or replace roof, whatever the repair is, you would definitely want to make sure that you include that language by a qualified contractor, by a licensed whatever. The situation with the repair addendum would be if the buyer has especially a FHA, rural development, or VA loan, that lender, that underwriter will not want this to be a part of the contract. So it may be that in order for that lender to process that buyer's loan or even submit it to the underwriter, this is going to have to be removed from the contract. So it comes in as pretty risky between buyer and seller. So you definitely want to preface, you can include it with your buyer and wait to remove it until all of those repairs are performed reasonable and satisfactory to the buyer. And then you could have this removed through an amendment. But there's always the risk of having to remove the repair addendum to satisfy the buyer's lender. And then the buyer is left wondering if the seller will actually perform these repairs as agreed upon. If that does become a concern, obviously the buyer does have the inspection report, inspection responses to fall back on, but those aren't a guarantee either. So just have some precaution when you do present a repair addendum. Buyer would sign, and again, you would add this to the purchase contract and make sure you check that addendum D box on page 11. Okay, secondary contract, addendum S. This would be if there is a primary contract already in place. So the property that the buyer's interested in purchasing is already under contract. But your buyer wants to present an offer as a secondary contract. So if the primary contract would terminate, then the secondary contract, if all terms are agreed upon, would then move into first place for that contract, for that property, and then pursue with the purchase. So secondary contract dated, this would be the date that you've dated all of your purchase contract documents. Property address, seller's name, buyer's name. The parties acknowledge that there is a pre-existing signed contract, primary contract for the sale of this property. This secondary contract is contingent upon the successful termination of the primary contract on or before whatever time, AM, PM, on whatever date, if not filled in within 5 working days after the effective date of the secondary contract. Remember, the effective date is the date all parties come into agreement. 5 days isn't very much time, but this would terminate if this is not filled in, or if it's X's or dashes or N/A's. You definitely want to have a conversation with the listing agent to find out, okay, when is the inspection contingency completed and fulfilled for the primary contract, or when is the finance contingency fulfilled? if your buyer, have that discussion with your buyer. If your buyer is willing to wait that time, say, you could put this 30 days out and see. The secondary buyer has the opportunity to terminate their secondary contract so long as it's in the secondary position at any time. So it does have to be, of course, by in writing with the termination. If earnest money is deposited, you would have to do the release of earnest money, but the seller would have to release that earnest money according to the terms of the secondary contract. The secondary buyer shall have the right to terminate. So that's the secondary buyer's right until, as so long as they present it in writing and it's prior to them becoming the primary buyer. Okay. The secondary contract will become the primary contract only if the present primary contract is terminated between seller and primary buyer. Seller is advised to seek legal counsel at any time the seller terminates the primary contract other than by mutual written release with primary buyer. Upon written notification to secondary buyer by seller of the successful termination of the primary contract, the secondary contract will become paramount and primary and in full force and effect. So it's possible, obviously, for your buyer as a secondary buyer to move into primary, and at that point you jump forward into full force and effect for the purchase of the property. All contingencies remain in force within the purchase contract, so you want to be aware of those dates and be true to those. Secondary buyer, your buyer would sign and date here, and again, you would check the Addendum S on your page 11 of your purchase contract if you're including this addendum with that purchase contract. Last but not least, we have the short sale contingency, the Addendum N. This would only be used if the purchase is a short sale. That's a whole nother discussion. Short sales are a completely different type of transaction that would require some definite coaching through. If the property you're showing, or if you're working with a buyer who is interested in short sale properties, then you definitely need to get some training on how to maneuver through a short sale, whether even as a listing agent or a buyer's agent. So definitely seek that information out from your coach or from me. We can go through the process together and help teach you how to maneuver through the short sale process. So this addendum would be used in the effect that your buyer is purchasing a short sale property. So if that's the case, we will go through the short sale process together. Just seek out some help. Buyers would sign, this would be an addenda to a short sale property. That is a brief synopsis of all of the addenda that could be attached to a purchase contract. So questions, confusion, reach out to your coaches, contact me. We are all here for you.